those appeals, subject to correction, those appeals are with regard to the commission wanting to create supernumerary posts. Let me the distinguishing feature is very important. To create supernumerary posts for candidates who are allegedly illegally appointed. They were losing their jobs.
Exactly.
We wanted to save them.
Dr. Patro, because of your affidavit, disclosure in your affidavit, maybe a mistake, maybe or something different you wanted to say, subsequently clarified.
But that was a very clear, it was an application, not an affidavit. It was a very clear statement, a prayer to give us leave to create supernumerary posts for candidates who have been removed from their service. This is a different set. Here, the 5 different categories of selection, those who are in the wait list, the genuine candidates, not those who are losing their jobs.
No.
The genuine candidates.
Dr. Patro, don't. Creation of supernumerary post is constant. How many posts were created, sought to be created, or proposed to be created? How many posts?
Total for work education, physical education, my lord, around 1400 something, my lord.
Around
1600.
Now the issue was related to this 1600. No,
Nothing with regard to them. Nothing with regard to them. Even the other categories, nothing with regard to those candidates who are genuinely.
No, the direction for, then why then the Advocate General concedes that this is.
My lord, may I?
Maybe when I create a supernumerary post, what is most important is that there has to be a reason, a valid reason. So one reason might not be acceptable, but a different reason might be acceptable. So creating supernumerary posts for genuine candidates in the waiting list might be reasonable. That is it. Creating supernumerary posts for illegally appointed candidates.
That was your disclosure in one of the affidavits. That suited the problem. Mr. Dasgupta, where is that affidavit? Or the application? Bring those material. Dr. Patro is now trying to distinguish it.
No, from day one I've been trying.
He is trying to distinguish it as if the affidavit or the application where the commission initially disclosed that this is to accommodate the teachers who have lost their job. Now that suited the problem.
Yes.
Justice Ganguly directed that all things, who took the decision and other things, CBI to inquire.
And it was appeal against the division bench, affirmed the order of
the Justice Ganguly.
From
now,
that, it went
from there, Supreme Court. Supreme Court admitted the SLP.
SLP of the commission as well as of the state.
Now he wants to make it a separate. That this is not the supernumerary post.
My lord, with deepest of respect, my lord, when the matter will be taken up before the Supreme Court, the argument will be whether the state has the power to create the
obvious question.
The issue is also
obvious question
pending before your lordship also.
Obvious. That was why earlier, before Mr. Dotto, earlier Advocate General, I wanted to know from him very specific. Make it clear. Can you assure this court that this will not be an issue before the Supreme Court?
And the Lane Advocate General in his usual fairness,
on instruction
in his usual fairness said, he cannot. The point must come up before this.
Obviously, it will come. Incidentally, or collaterally.
My lord, two things, my lord. First, the SLP is withdrawn, or a clarification is sought from the.
Yes, I want that clarification or withdrawal of those SLPs. Let a state and commission withdraw those SLPs.
Super.